Thank you so much, Matthew. So hello, everyone. Welcome to our fourth OUSSG talk for Trinity 2021. Today, we're joined by Jeff Kosseff, who will be talking to us today about reforming cybersecurity law to bolster national security. Jeff Kosseff is an assistant professor of cybersecurity law in the United States Naval Academy's Cyber Science Department. His latest book, The 26 Words That Created the Internet, A History of Section 230 of the Communications Decency Act, was published in 2019 by Cornell University Press. He is also the author of Cybersecurity Law, a textbook and treatise. His articles have appeared in the Iowa Law Review, Wake Forest Law Review, Computer Law and Security Review, and other law reviews and technology law journals. A full list of his publications is available at jeffkosseff.com. His research interests include cybersecurity regulation, online intermediary liability, and the law of armed conflict as applied to cyberspace. Before becoming a lawyer, he was a technology and political journalist for The Oregonian and a finalist for the Pulitzer Prize for National Reporting and recipient of the George Polk Award for National Reporting. Jeff, over to you.
Great. Well, thank you so much for having me. And before I get started, I have to give the disclaimer, which I should know by heart by now, that everything I say is only my opinion and not on behalf of the Naval Academy, Department of Navy, or Department of Defense, or anyone else, just my own views. And I'm really excited to be here, in part, as I was telling folks before this, pretty much every talk I give is about Section 230 these days, which is, for those of you who don't know it, it's the law in the United States that provides protections for, really almost absolute protections for websites and online services for user content related claims. So I'm happy to be talking about something different here. That said, I hopefully we'll have some time for some dialogue, and if anyone wants to talk about that, I'm always game to talk about that. But what I'm going to talk about today is cybersecurity law and how to reform it for national security. And so this gets into two of my research interests. My other one is Section 230, but the other two are the law of armed conflict as applied to cyber, and then cybersecurity regulation. This is going to actually have me speaking mostly about cybersecurity regulation, which isn't necessarily intuitive. So I started at the Naval Academy after I was doing cybersecurity law in the private sector in 2015. And I thought, I'm at the Naval Academy, we're looking at cyber as a national security issue. So most of my time is going to be spent looking at, what constitutes an armed attack in cyberspace that allows us to use self-defense. And that is something that I research. Most years or at least recently, I've been presenting papers at the NATO Tallinn Conference, which is an amazing gathering of people talking about those issues. But one area where I think national security is even more urgent than law of armed conflict is how do we secure the private sector? So whether that's regulation or assistance. And that's really, for the United States, that's been something when you look over the past 5 or 10 years and you look at the major cyber incidents, most of the really significant harms that we've experienced have not been attacks that have been targeting military or civilian government computers. To be sure, there have been many, but it has been attacks targeting the private sector. And even that can have spillover effects to the government, or just in and of itself by attacking the private sector and exploiting their vulnerabilities. The adversary can have significant national security and economic harm, can inflict that harm on the United States. And So the challenge for the United States has been both how to secure our government's computers, but even more dire and more difficult is how do we secure the private sector's assets in a way that exercises the limited powers that the government has under the Constitution, while also respecting various constitutional rights of individuals, of companies, whether it be the First Amendment's protection for free speech or the Fourth Amendment's protection against unreasonable searches and seizures. There frankly just are some substantial limits as to what the government is able to do. And then you layer on top of that the dual sovereign system that the United States has, where the federal government has supreme but limited powers, and the states have plenary powers, but they are subsumed if there's any conflicting federal law. So what's developed for cybersecurity, I thought what I would do is first talk a bit about what the US legal framework is for cybersecurity of the private sector, and then talk about some principles that I've proposed to help guide reforms that help serve both the private sector and more generally the national security interests of the United States. So in terms of what laws currently exist, I'm sure many of you are very familiar. I'm not sure if in the UK they use the same sort of lingo, but for cybersecurity, but the CIA Triad, the confidentiality, integrity, and availability Triad. In the United States, most of our laws, or at least the laws that sort of get the most attention and take the most time from companies to comply with, focus on the C of the CIA Triad, the confidentiality problem. And it's even more so just a narrow part of the C. It's the confidentiality, particularly of personal information that can be used to cause financial harm. So things like identity theft, stealing someone's credit card number, their social security number. We provide significant protection under our laws for that type of information. And I think that's in part due to the fact that many of our data security laws were passed about 15 years ago or so. And at the time, the big concern was not ransomware. It wasn't about malware that could stop a shipping company from operating for weeks or that could shut down a pipeline. Those were all kind of theoretical issues, but really what people were concerned about were the cases of identity theft, of a retailer having its credit card systems breached, that sort of thing. So what we have is primarily at the state level. And this is where it gets a little difficult because we have 50 states plus the District of Columbia plus territories. All of them have what are known as data breach notification laws, and they all vary just a little bit. They all have a baseline where they require notification in certain cases if the resident of that state has had their name in combination with their social security number, driver's license, or bank account or credit card number disclosed. And what's important to note is these laws apply based not on where the company is, but where their residents are located. So for all of these data breach notice laws and data security laws, effectively most companies have to comply with all 51 different laws because unless you're a really small company, you're going to have customers or employees in every state. So some states, but states all add to that list. So some states cover passport numbers, other states cover biometrics, and they all have different procedures for how people have to get notified, time frames in which they have to be notified. Many, but not all states allow companies to decide that basically there's not really a risk of harm, so people don't need to be notified. There's a lot of kind of new and I would say fairly critical information that's not protected at all, that's not covered by these data breach notice laws. I would say most concerning is geolocation data. I mean, I personally am much more concerned about some adverse nation being able to have a virtual map of everywhere that I've been in the past 3 years, rather than them even having my social security number. We've figured out ways to deal with identity theft pretty well, but that's kind of the outdated nature of these notice laws. And more fundamentally, these breach notice laws have a real shortcoming in that they're really focused on telling people after their data has been compromised and making sure that companies follow proper procedures to notify after a breach has happened. And if they do that, then they're fine. I have some problems with that, primarily because I'd rather have our legal system focused on preventing the breach in the first place. And unfortunately, the data breach notice laws, because there are 51 of them, and because they all have these different requirements, different timing, companies, and I've worked on probably more than 50 different cybersecurity incidents as a lawyer advising companies on response. And a lot of the time that companies spend in the initial hours and days and weeks after a breach is not fully spent on mitigating the harms, but it's on figuring out how do we notify people and what notice do we publish on our website and things like that. So unfortunately, we're very much focused on this backward-looking system. Now, about half of the states have data security laws, which most of them just say if you process any data of people who are located in our country, you have to have reasonable data security processes. And they don't define that. I think with the assumption that that could be something the courts or regulators could define later. There are a few states that lay out more specific requirements, but there are only about 3 or 4 of them that do that. So there's not all that much guidance. Now, we do at the federal level. At the federal level, we do not have a general data security law or a general cybersecurity law. What we have at the federal level is consumer protection law, the Federal Trade Commission Act, which is Section 5 of that act, which is enforced by the Federal Trade Commission. And that is a law that prohibits unfair and deceptive trade practices. And what the FTC for pretty much 2 decades has basically believed is that businesses that have woefully inadequate data security practices can face potential enforcement actions under both the unfairness prong and the deception prong. So under the unfairness prong, it's if there's really some unreasonable risk with data security that a company has taken and there's no countervailing benefits, the FTC might find that that was an unreasonable data security practice. For the deception, that would basically be if a company lied, let's say in their privacy policy, if they said, we will never have a data breach, that would be really bad. Legal move for a company to do, but that would be the sort of thing that would trigger the deception thing. The problem with the FTC, with relying on the FTC, even though the courts have affirmed the FTC's ability to bring enforcement actions under Section 5, there are 2 main problems. First is resources. The office within the FTC that enforces both privacy and data security is 50 staffers total for the entire United States. So this really limits their ability to really have broad enforcement. They have to be very selective in terms of what types of cases that they bring. The other thing is that for a first violation of the FTC Act, Typically, what happens is they don't go to court. There's a settlement, and basically the company agrees to make changes to its data security and have that overseen by the FTC. But there's not a fine for the first violation. There can be for subsequent violations. But people argue about whether the FTC has sufficient punitive resources, or if it's just kind of a slap on the wrist and an embarrassing press release that the FTC issued. So the FTC is fairly limited in what it can do. We do have more stringent data security for particular sectors. So, for example, financial institutions, they're bound by something called the Gramm-Leach-Bliley Act, which has specific regulations. Healthcare providers and insurers are bound by HIPAA, which is our health privacy law that also has data security provisions. So we do have some sector-specific laws, but not all that many. So now, what gives businesses the incentive to secure their data? There could be reputational issues. So there's been mixed research as to how, at least for within the United States, as to how whether consumers will stop patronizing a company because of its inadequate data security if it's had a breach. But interestingly enough, even in some really egregious situations, there have been actual upticks in business after a data breach. So the other reason might be to fear a lawsuit. And we're starting to see some more stringent data security related laws that allow people to have private rights of actions, including class actions. So one example would be California passed kind of a law that's not the GDPR, but it at least has some similar principles to the GDPR. And it does not allow a private right of action for privacy-related violations, but it does allow a private right of action for data breach-related violations. So other types of class actions that people bring are under general common law. So things like negligence, breach of contract, breach of warranty, violations of state consumer protection law. Now, class actions, the Supreme Court in general, not just for data breaches, has created some increasing barriers to bringing class actions in terms of when a small group of plaintiffs is allowed to represent a much larger class of affected individuals. The more difficult part, and this is something where the courts are really split in the United States, is the issue that comes down to when someone has what's known as standing to bring a lawsuit, at least in federal court. So to have standing, there has to be a case or controversy. And in general, the belief is that, or the line of thinking is you have to have what's known as an injury in fact. And where the courts are split when it comes to data security is that many of them have held that even just the mere, if you've had a breach, even if you haven't had identity theft or any other concrete harm happen yet, the mere potential of it happening because of the breach is sufficient for standing. But we have other courts that have said if you have not had the harm happen yet, if you have not had identity theft or something like it happen that's caused this particular loss, you're not going to have standing. So my guess, and it's just a guess, I think the Supreme Court is going to eventually hear a case that resolves this split among the courts. So, but even with litigation, what we often see is we see these very large national companies settle for what I would say is not a substantial or not an existential amount of money. It's a lot of money for us, but when you're looking at a company that has billions and billions of dollars of revenue, if they have to pay a $40 million settlement to end a class action lawsuit, they're going to survive and their share price won't be really significantly affected. So we're not really able to rely all that heavily on the litigation system and to provide the incentive, at least as it is now, to provide the incentive that we need to encourage better cybersecurity. Now, what about going after the other side of the coin, the people who are hacking? So in the United States, we have a number of hacking laws or anti-hacking laws. Every state has one. At the federal level, we have the Computer Fraud and Abuse Act, which has some potentially significant amounts of prison time that people have to serve if they're convicted of violating it. There are a lot of different factors, including what type of hacking, whether it's a repeat offender, how much damage they've caused, things like that. It also allows the companies that have been, or the individuals who have been the victims of the hacking to bring a lawsuit against the person who did the hacking. Now, the problem with the Computer Fraud and Abuse Act and similar laws is that, at least for the United States, so many of the really harmful hacks that we experience are not conducted by people who are in the United States. They're conducted by, operated by people in other countries, oftentimes Russia, North Korea, Iran, and China. Now, there is an existing arrangement called the Budapest Convention, which the United States and I think more than 50 other countries are members of, that, among other things, allows for the extradition under certain circumstances of people who have been indicted for cybercrime so they can stand trial. Now, the problem is that those 4 countries I just named, Russia, Iran, North Korea, and China, are not members of the Budapest Convention. So we've actually secured indictments against foreign hackers, particularly over the past few years. Realistically, there's little chance that we're ever going to actually see them in US court. It can make things difficult for them. It limits their ability to travel, but it does not mean that they're going to end up going to going to trial in the United States, possibly facing prison time. So it's hard to rely on that because, it is used a lot. I would say the Computer Fraud and Abuse Act in particular. I haven't seen any recent statistics, but at least based on court opinions, it's used more in the civil context. And it's used more by companies that are going after former employees who either use their old passwords, or they allegedly exceeded their authorized access while they were still at the company to get confidential information that they weren't authorized to use in their new job. It's really become, we have a separate trade secrets law, but it's really almost become like a trade secrets law. And a lot of the really bad hacks that we've been experiencing, we don't necessarily see the prosecutions and litigation under the CFA. So that kind of gives at least a high-level landscape. There's a lot of other things, but since we're limited to an hour, and I really want to, I love having dialogues about this. I don't want to spend the whole hour just talking about law, about what the legal landscape is. That's kind of my high-level view of it. Now, my proposals, I wrote an article that was published last year called Hacking Cybersecurity Law, where I basically go through a lot of what I just talked about with what I see as sort of some of the shortcomings of private sector cybersecurity law in the United States. And what I talk about is principles that could guide us as we're thinking about how to basically create a more coherent system of cybersecurity regulation. And so I have 7 principles. The first one is that they need to be informed. And so you may have seen some memes or some jokes about some recent, not recent, but really over the past few years, congressional hearings where members of Congress ask some fairly basic questions to tech CEOs, and it's a little surprising they don't necessarily know the answers to those questions. And part of the problem here is that I don't think we've invested enough in the necessary scientific resources for both lawmaking and regulation to make sure that they're informed. I mean, we're regulating dynamic technology, and there used to be, it was eliminated about 25 years ago, there used to be an internal science and technology think tank within Congress. As I propose, I think that it would be a good idea to revive that, to have sort of a nonpartisan source of information where if congressional staffers need information about how a particular, how does quantum work, things like that, that would be something where they'd be able to go and get informed, objective reports about that to help guide their policymaking. That's pretty uncontroversial. The next one, the next principle, the second one that I have is probably a little more controversial, and that would be clarity. You would think, well, why would clarity be controversial? Well, the reason is that my problem with a lot of our current legal standards is that they're all tied to these fairly vague balancing tests of reasonable data security. And I understand the need to have some flexibility both for companies and for courts and for regulators and plaintiffs and consumers. But in my experience, having advised chief information security officers, what they don't come to me and say, you know, I want to have a data breach. That would not make sense. But what they do say is, I have a limited budget. What do I invest in? Am I expected to have multi-factor authentication? What encryption standard am I expected to have? What should be the specific procedures for employee access? What about least privilege? Those sorts of things. If we had more laws that outlined what even would be considered minimal responsibilities, I think that would give a lot more clarity than just saying, oh, you got to be reasonable. I always tried to avoid as much as possible telling a CISO, be reasonable, because they say, no, I've got X number of dollars. I don't want to be reasonable. I want to not face a class action lawsuit. I want to not face a regulatory action. So that would be a very important step to really help give as much clarity as possible without binding an agency too much. So, or without sort of locking the law in place without allowing it to change. And that gets me to my third guiding principle, which is adaptive. So the problem, at least for US law, is that Congress doesn't pass all that many laws. This gets to the gridlock that's been a problem for a very long time. Congress will name post offices, that sort of thing. But in terms of substantive laws, even if you've got members of both parties agreeing to it, people start trying to put their pet projects in, and it's known as the Christmas tree effect. You put too many ornaments on the tree and it collapses under its own weight. So if we do get a chance to pass a federal cybersecurity law, it's probably not going to be something that Congress is able to update every year, because you're going to have to go through the same political machinations over and over again, and it becomes really, really difficult. But at the same time, technology won't stand still for 20 years as we wait for Congress to pass the next cybersecurity law. So what I think would be helpful would be to give regulatory agencies the ability to pass pretty broad ability to pass rules and regulations under congressionally set standards, because the regulatory agencies are much more nimble and able to more quickly adapt to the changes in technology. Now, we have our own problems with regulatory agencies. Rules can be challenged in court, and they almost always are challenged if they're important regulations, and that can go on for years. But this at least is more I think it would give more flexibility and more nimbleness than if we were to just wait for Congress to pass a new law every few decades. My fourth principle is comprehensive. So as I talked about in the beginning, the CIA Triad, confidentiality, integrity, and availability. My belief, having written a textbook on cybersecurity law and been studying it and practicing it, is that so many of our laws focus on the C. And they also don't focus on all of the C. They don't focus on, I don't think they focus enough on trade secrets, on things that don't contain financial information. I think they also don't focus enough on private information that can really harm individuals and potentially national security. One example of this, this happened about 5 years ago. There actually still is, I think, a website called Ashley Madison, which is a place where, I mean, for lack of a better description, married people would go to find other married people to have affairs with them. And they promised some option where they would delete everyone's data if they paid extra money to them. There was a hacker who discovered that they were not actually deleting the data, and in fact was able to hack their database and get all of the registration names and email addresses, hack the database, and leak the entire thing. And I mean, these were a lot of names. I don't remember how many, but I mean, this was a lot. And I mean, this led to obviously families being destroyed. There were suicides that were related to it. And this is the type of thing that are just something like names and email addresses. Our cybersecurity laws don't really focus all that much on. If it was names, email addresses, and credit card numbers, then it would focus on it. What it also doesn't focus on is availability. So all of the ransomware that we're seeing. Our data breach notice laws are not going to be very much help for responding to and preventing the ransomware that can shut down hospitals that we're seeing throughout the United States. So I think having a more comprehensive view of cybersecurity and going beyond just the confidentiality aspect is really important. The fifth principle is cohesive. So as I talked about, we have some federal laws and regulations, but a lot of what's going on is at the state level. And that's understandable, because if Congress isn't passing stuff, then the states say, well, we've got to. I think that's got to change. What I would favor is a strong, punitive, federal cybersecurity law that allows a private right of action, but also preempts all of the state laws. Because the state laws all have the same goal. They're generally doing the same thing, but they're doing it in a different way. And I don't think that, I mean, it benefits law firms quite a bit. I mean, there are a lot of lawyers who have made partner based on the fact that they understand the nuances of North Dakota's data breach notification law. But I don't know if it's necessarily in the national interests to have this patchwork of different regulations. So having cohesive laws is really important. My sixth principle is global. So I've been talking so far primarily about the US as with its internal cybersecurity and making sure that companies in the United States can mitigate damage, for example. So I think we need to go a step further, and rather than just being cohesive nationally, to the best that we can, being cohesive with regulations like the GDPR, like the NIS directive, trying to make it so that we're addressing a global threat. Because frankly, it is a global problem and it does not just end at a nation's borders. And the seventh principle is collaborative. So we're actually starting to see this. I wrote this article last year. I mean, I started it 2 years ago. The government is starting to move in that direction. Actually, my coworker at the Naval Academy was just nominated to be the nation's first ever national cyber director. And I think that position is a huge step forward in having a collaborative environment where, because right now we have dozens of different federal agencies that have different cybersecurity functions. We need to have that more centralized and they have to be working with one another. I also think that they need to be doing a better job working with companies. So as I talked about earlier, there's no rational CISO that says, I want to have a data breach. Or I don't care if I have a data breach. They clearly, the general interests of companies in not having breaches, not having ransomware attacks, is aligned with the federal government. And we have some information sharing programs. I think we need to expand on those in the recognition that regulation alone is not necessarily the solution, but helping figure out how can we help the companies to prevent the attacks that harm them and harm our national security and harm individuals. So I've been talking for a while, and I guess we have maybe about 15 minutes left. So I would really like to hear what folks have to say and have a dialogue, take any questions anyone might have.
Thank you so much, Mr. Kosseff. So I think now is a good time to enter your questions into the chat box, either on our live stream or on our members only platform. And we can take a few questions from the audience. While we're waiting for that, I have a couple of questions. You touched on several, I think, important areas that raised a couple of questions in my mind. I wonder what, how you see the role for private law in this context of internet exceptionalism and some of the nuances that you highlighted, and then also I wonder what role you see for or how you see the evolution of law accommodating for offensive countermeasures as a deterrent and or method of defense.
Okay, so just a minute. When you're talking about internet exceptionalism, you're talking, your question is more focused on sort of intermediary liability issues.
Precisely, yeah.
Yeah, so for that question, I think that I mean, the United States obviously is exceptional in its internet exceptionalism because of Section 230. And that in itself has raised some national security issues. We've had some cases brought against social media platforms, for example, because they allowed ISIS and other terrorist groups they allegedly allowed them to recruit, spread propaganda, and they didn't engage sufficiently to stop that. So I think that does have some national security implications and the criticisms of the platforms is that they're not doing enough to combat this harmful content. In terms of offensive countermeasures, this is something that I've been studying quite a bit, and in part because when we're talking about LOAC and international law, so much of the discussion over the past 2 decades about cyber and LOAC has been what is the equivalent of the cyber Pearl Harbor that allows self-defense. Fortunately, we, at least the United States, has not experienced, in my opinion, an attack that rises to that level. I think that's great. I hope that's the case for the future. That's not to say we don't face aggression. We face aggression all the time that's just underneath the level of armed attack. So that doesn't allow us to, it's not a use of force, it's not an armed attack, but it's all sorts of really damaging things, such as causing damage to companies' systems, trying to get voter registration data, that sort of thing. And that's where countermeasures really can come in. And because I mean, these would be illegal acts that would violate sovereignty, had we not experienced our own unlawful actions, and they're intended to stop those unlawful actions. I really think countermeasures are at the heart of this US operational strategy of defend forward, which is a little more aggressive than the active defense of the past. And so I think countermeasures are really integral legal justification to what we have to do while we're dealing with all of these persistent threats that are just acting below the level of armed conflict.
Great, thank you. I do have a quick follow-up. We've been exploring this theme of naval strategy, and I wonder if this is a little beyond the scope of your talk specifically, but I wonder if you might expand on some of the nuances in terms of cybersecurity law in terms of maritime conflict and some of the developments that we're seeing in that theater.
Yeah, so I mean, I think that a lot of it comes down to, I mean, there obviously are the issues of, you know, the high seas versus closer to shore. But I mean, I think in terms of maritime conflict, it still gets back to the law. I mean, from the legal perspective, there's sort of strategic issues as well, but it still gets back to these core concepts of the law of armed conflict. I think there are some definite sovereignty issues in particular, such as what do you actually consider to be an illegal act in cyber or a cyber attack, and where is the harm caused, and does it transit across undersea cables, or does it but is it just passive until it reaches its target? And I mean, I think that there's when you read the Tallinn manual and sort of the at least academic commentary on this, it's really still focused more when you're looking at violations of sovereignty and other illegal acts. It's really still focused on where is the ultimate harm caused. So this gets more complicated for cloud computing, for example, but I mean, it really still will always get back to the core principles of the law of armed conflict and jus ad bellum.
Great. Thanks. So,
Philip, I believe there are two people willing to speak here on the chat.
Oh, great.
If you in the order, if you want, in the order that I saw the hands, I saw Andy Laurie first, and then Matthew Rogers.
Super. Thanks, thanks, Philip. Thanks for joining us today, Jeff. Really interesting to hear the detailed insights that you bring. I know it only came out last week, so it might be a bit soon to get into too much detail. But do you have a view on President Biden's executive order on improving national cybersecurity? Do you think that it fits in with your guiding principles? And where it says that the aim is for the federal government to lead by example, do you think that's going to work, and that it'll cause a trickle-down effect into cybersecurity in the private sector? Many thanks.
Sure. So continuing my caveat that I'm only speaking on my own behalf and not on behalf of the federal government, I think it is a good step. I think that it's overdue. I think particularly when it comes to federal contractors, we've had a bunch of sort of scattered regulations on the books, but they've not been enforced consistently. And I think this is, I think leading by example is one important part, but the other part is just doing our best to secure, I mean, especially after SolarWinds, I think recognizing that we rely on such a long supply chain, I think that's important. Now, the challenge, it's definitely not a panacea, because an executive order can only do so much, because the executive order has to act within the bounds of the existing laws that Congress has passed. So that's why you see so much focus in it, for example, on federal contractors and federal government's internal systems, because that's what can be dealt with in an executive order. But I mean, ultimately, I don't think this is a substitute for what we really need, which is a comprehensive federal cybersecurity law.
Okay, Matt, would you like to go next with your question?
Sure. Thank you very much for the talk. I guess my question is, if you're doing this sort of comprehensive federal cybersecurity law and it mandates certain actions on the behalf of, say, like an IoT device or on a network, say somebody from China or something is selling a product and it requires certain cybersecurity regulations to be allowed to fit under those federal cybersecurity laws, who's monitoring it? And to do so, do they have to give us their source code or something like that? I mean, do you think that would be something that anybody would even be willing to accept? Or is there even a government agency who would be willing to take that task on?
So just to make, you're saying if for China's law of saying
no, like for U.S. federal law, if somebody wanted to sell, say, a product like an IoT device, for instance, a smart toaster, and determine that there wasn't some sort of attack built into it that added insecurity to networks as basically a ticking time bomb. Unless your proposal doesn't apply to IoT devices, I misunderstood, in which case I apologize. But so who's monitoring and how do you monitor those networks in a way beyond, you can make specific demands, of course, but in terms of making sure that they're following them, how do you build like a rigorous testing framework that actually monitors that?
Well, so that yeah, I think that's a really good question. And California actually just did this with IoT devices a few years ago, and they basically, I would say it's a fairly weak law. It basically just says you need to have reasonable security, and one way of showing reasonableness is not having a default password. So if we were to, but I think that's a good step, because when you look at some of the real problems with IoT devices, it's that so many of them have had default passwords of 0000, and you suddenly have people's webcams being freely available on the internet to anyone. So in terms of who would police it, that's tough. So I mean, you could create a private right of action where you give lawyers effectively the sufficient incentive that they would be on the lookout. And we've seen that on the privacy side of things, we see that quite a bit. This is a little more difficult because it might require reverse engineering and that sort of thing. So, I mean, investing in regulatory agencies also is a good thing, but the problem with that is having the capacity to deal with all of the products that would be on the market. So, yeah, I mean, I think IoT poses special challenges just because of the nature of them and the difficulty of finding what might be a violation. I mean, there could be easy things to find, like, do they use default passwords? That's a fairly easy thing. But when it comes to more like, is there a backdoor for monitoring by the Chinese government, that does require more resources, whether it's from private sector lawyers or from regulators.
Thank you.
Okay, thank you. We have about 5 minutes, if I'm not wrong, before you have to leave. So I do see a question from our president, Anna, and then I would like to jump in and ask one final question. So we take those two and then conclude the session, if that's okay. So Anna, please go ahead.
Thank you so much. And thank you so much for your talk, Mr. Kosseff. My question was regarding the harmonization of the legislation. So you were talking about there being more and more steps to harmonize legislation nationally, for example, in one unique agency. And I was wondering whether you think it might be perhaps more efficient to have such legislation harmonized globally, and if there's maybe any scope for such a global agency to engage in regulating these issues.
Yeah, I think that's
sorry.
Sure.
No, go ahead. Sorry, I'll just take that and I'll ask later.
Yeah, I think that's a great question. And I think the challenge that we have a few challenges with that, but the big one is China. And I think that when we're talking global, if we're talking everywhere, I think they have their own cybersecurity law, which, in my opinion, is effectively a way for them to conduct surveillance and further crack down on the ability of their citizens to speak. And I think it's a real problem. And I don't see how the UK, how the United States would ever be able to get anywhere close to the same page as China or Russia on a cybersecurity law, on a global cybersecurity law. I think you could consider whether there could be some sort of membership group where it's multiple countries. Even then, there could be difficulties because even though we're starting to see some states pass laws that have some of the GDPR principles in them, the problem is that they don't go as far and they're applied differently in the United States because there are certain things that GDPR and really, frankly, the European Court of Human Rights have done that I think are very positive steps in terms of privacy protection that would not satisfy the First Amendment in the United States. I think most notably is the right to be forgotten. That's something that a U.S. court would strike down immediately as a First Amendment violation. And that comes to the fundamental nature of the United States really valuing free expression more than things like privacy, while in Europe, privacy is really a fundamental human right. So I think it's more possible for sort of the Western democracies, but I think even there it might be difficult to really come to a full agreement. But maybe having just general principles that give some flexibility, that would even be useful for companies, I think.
Thank you. And I'll just ask one quick final question that relates to as Anna was asking about the international possibility of developing regulation, I would like to ask about the domestic position in the US. And I was wondering, it struck me that you mentioned that many of the laws that we see today were developed about 15 years ago. And so I wonder what led those, or what climate led to those laws being passed in the first place, and what would we need to see another wave of regulation in the cyber realm today. So as you were saying, some of these areas, there are many areas which are under-regulated or unregulated. So I was wondering, what do you need in order to not just start a debate, but get legislation passed at a fast pace? So perhaps, do you need something like a Cyber Pearl Harbor, or would you say just a series of successive and cyber attacks would be sufficient, or what else should we expect, if you can expect that?
Yeah, so I frankly think that a Cyber Pearl Harbor might be necessary, but might not be sufficient because we've had these persistent attacks. This is not new, and this has not been enough to get past the gridlock. And the gridlock in the United States really comes down to a certain group of people in Congress wanting there to be an overriding federal law that preempts the state laws, while others say they don't want the state laws preempted. And the second issue is that when the people want to preempt the state laws, they also want to preempt the abilities of individuals to sue. And that's the sticking point. and we've gotten no traction. And I don't know, I mean, I frankly don't know if we ever will. In terms of what precipitated the earlier laws, most of them were at the state level, and it's easier to pass laws at the state level. And that's why we've seen so much action both on cybersecurity and privacy being done at the states. I feel bad being a guy from the US coming to Oxford and just saying, oh yeah, our political system really needs some fixing. But I mean, really, it's gridlock, and I frankly don't know what the catalyst would be that would actually get some movement on this.
Oh, thank you. Thank you for this very interesting answer and for the extremely interesting talk that we've had so far, Mr. Kosseff. We have come to the hour, so I understand that we have to conclude our broadcast now. And thank you again to our guests for being with us, and for Philip for moderating and starting the discussion. Before concluding, I just want to remind everyone of next week's event, which is going to be at a different time on Tuesday at 4:30 p.m., not at 7 as usual. And we're going to be hosting Dr. Imogen Parsons, who is going to talk about intervening in conflict, how international interventions begin and how they end. So without further ado, I thank again our speaker and all the audience for being here and following us. And I look forward to seeing you again next week. Thank you.